Here's something that's been bothering me. Every time you hear about someone suing a company because a product hurt them, bad food, a defective gadget, whatever it is, there's a real chance that lawsuit is leaning on a case from 1928 about a bottle of ginger beer. And here's the part that genuinely got me when I found it. We don't actually know if there was a snail in that bottle. The most famous snail in legal history might not have existed at all. And that's not even the strangest part of this story. Let's start at the beginning. Paisley, Scotland. August 1928. A woman named May Donoghue, about 40 by most accounts, goes to a café called the Wellmeadow with a friend after a day out. Her friend treats her to something popular at the time, a Scotsman's float, ice cream with ginger beer poured over the top. The ginger beer arrives in a bottle made of dark, opaque glass, completely standard for the era, but it means nobody can actually see what's inside until it's poured. The cafe owner opens the bottle and pours some over May's ice cream. She eats some, drinks some. Then her friend picks up the bottle to top off the glass, and along with the ginger beer, something else comes out. May would later say it was a decomposed snail. She says she became severely ill in the hours afterward, the kind of reaction consistent with drinking something contaminated, not just feeling a bit off. Whatever exactly happened in that cafe, May Donoghue came away convinced that a snail had been bottled along with her ginger beer, and that it had made her sick. And she decided she wasn't going to just let that go. So May does what you'd probably do. She decides to take this to court. Except, and this is where the story gets interesting in a way that has nothing to do with the snail, there's a problem. Under the law, as it stood in 1928, if a product hurts you, you can generally only sue the person you bought it from, because your legal claim comes from the contract between you and them. May didn't buy that ginger beer. Her friend did. May was just there. A bystander, legally speaking, even though she's the one who got sick. So, under the rules as they stood, the actual injured person had no legal relationship with anyone involved in making or selling that bottle, and therefore, on paper, no case. Not because anyone doubted she got sick, because of who happened to hand over the money. This wasn't some random rule someone made up to mess with May. It traced back nearly a century to an 1842 case about a stagecoach wheel that collapsed and injured the driver. The court ruled that the wheel's manufacturer couldn't be sued by the driver because the manufacturer's contract was with the coach company, not the driver personally. For decades, that logic held. Your legal protection came from contracts, and contracts only ran between the people who'd actually signed them. Everyone else, including, often, the actual end user of a product, was legally invisible. May Donoghue, in 1928, was about to become the person who finally cracked that wall open. Sit with that for a second. That's genuinely wild. The entire legal question wasn't whether a snail ended up in this woman's drink and made her sick. It was whether the right person had handed over the money for the bottle. If her friend hadn't been the one to pay, this case doesn't exist, the snail doesn't matter, and modern injury law looks completely different today. The legal system was about to decide this whole thing based on a technicality about a transaction. May's lawyers didn't give up. They argued this old contract-based rule was wrong, or at least incomplete, and pushed the case all the way to the House of Lords, which at the time was the highest court in the UK. And the Lords were genuinely split on this. It wasn't an easy call. The final vote was 3-2. The majority, led by a judge named Lord Atkin, came up with something that's now known as the neighbor principle. The idea: you owe a duty of care to anyone you can reasonably foresee being affected by what you do, whether or not you have a contract with them. A company that bottles ginger beer for sale to the public owes a duty to the person who eventually drinks it, contract or no contract, because that's exactly the kind of harm they should have been able to foresee. And here's where it gets strange. You'd assume the next step was a trial. Lawyers, witnesses, somebody actually examining a bottle with a snail in it. That never happened. The House of Lords ruling only decided whether the case was even legally allowed to proceed at all. It was sent back down for an actual trial, to establish whether any of this was even true. And before that trial could happen, the manufacturer died, and his estate settled the case out of court for a relatively modest sum. No trial, no witnesses, no snail, ever, examined by anyone under oath. Whether May Donoghue's story was even accurate was never tested as fact. It just stopped mattering, legally. And there's a notable theory in legal academia, sourced to people who were reportedly involved at the time, that this might have been deliberately set up as a test case from the start. A vehicle built to get this exact legal question in front of the Lords, a snail or no snail. To recap, the most important negligence case in the English-speaking world might be built on facts nobody ever proved, possibly engineered from the start to produce exactly this ruling. And it worked. That's either the most accidental landmark case in legal history, or the most successful one, depending on how cynical you're feeling today. Here's why none of that ends up mattering. Lord Atkin's neighbor principle, the idea that you owe a duty of care to anyone you could reasonably foresee being harmed, became the foundation of modern negligence law, not just in the UK, but across the English-speaking world, generation after generation. Every time you've heard about someone suing a manufacturer over a contaminated food product, a company being sued because they should have known something was dangerous, or basically any, they had a duty to protect me from this lawsuit. That thread runs back to this case. The actual facts, the café, the bottle, whether there really was a snail. None of that survived. The principle did. 90-plus years later, it's still quietly running in the background of injury law every single day. And that's the thing I keep coming back to with this one. The story everyone tells is woman finds snail, sues, makes legal history. The real story is a legal technicality almost threw the whole thing out before anyone checked whether the snail was even real. And the principle survived anyway, snail or no snail, for almost a century. Quick note: this is commentary and legal analysis for educational purposes, not legal advice, and I'm not your attorney. If you liked this one, let me know what old case you want broken down next.